I have watched defendants enter my courtroom with fear in their eyes. I have watched them shake, cry, argue, and sometimes beg before a single piece of evidence was even shown. But arrogance has a different sound. It does not tremble, it laughs. And I will never forget the day Karen Whitmore leaned back in her chair, looked across my courtroom as though the entire proceeding amused her, and laughed directly at me while a young father tried to explain why he was about to lose everything. She thought that laugh made her look powerful. She thought it made him look small. She thought it made me look outdated, impatient, and easy to dismiss. What Karen did not know was that the very sentence she laughed at would become the doorway to a truth she had spent months hiding. And once that door opened, every word she had spoken began turning against her. Before we go any further, make sure you have subscribed to this channel for more powerful courtroom stories like this one. And if you haven't subscribed yet, do it now. Also, comment below and tell us where you are watching this video from. Now let me take you back to where this case truly began. The plaintiff was a man named Ethan Caldwell, 37 years old. Single father, owner of a small mobile repair service. He fixed appliances, small engines, generators, air conditioning units, and anything else people could not afford to replace. His hands were rough. His shirt was clean but worn, and when he placed his folder on the table, he did it carefully, as if those papers were the only thing standing between him and complete financial collapse. Across from him sat Karen Whitmore, 48 years old, expensive cream blazer, gold watch, diamond earrings, a handbag placed on the table like a trophy. She did not look worried. She did not look respectful. She looked entertained. That bothered me immediately. Years in a courtroom teach you that people reveal themselves before testimony begins. Ethan kept looking at his documents, as if reminding himself not to forget anything. Karen kept looking at Ethan, as if waiting for him to embarrass himself. The case involved $31,000. According to Ethan, Karen hired him after a power surge damaged several systems inside her rental property. She claimed she needed urgent repairs because tenants were arriving within the week. Ethan worked 4 straight days, replaced damaged units, repaired wiring connections, restored refrigeration, repaired the backup generator, and documented every expense. Karen approved the work. Karen thanked him in writing. Karen allowed the tenants to move in. Then she refused to pay. Her defense was simple. She claimed Ethan had taken advantage of her. When I asked how, she smiled. Because people like him see a nice house and assume they can charge whatever they want. The room became quiet. Ethan lowered his eyes. I watched him. A man who is angry looks different from a man who is ashamed. Ethan was not angry. He was trying not to appear wounded. That mattered. I asked Karen whether she disputed that the work had been performed. She leaned back. I dispute that it was worth anything. Was the power restored? Yes. Was the refrigerator repaired? Yes. Was the generator repaired? Yes. But were the tenants able to move in? She hesitated, only briefly. Yes. The spectators shifted slightly. Karen noticed, and then she laughed, not loudly, not uncontrollably. Just enough to let everyone know she found the questions beneath her. I looked at her for several seconds. She kept smiling. Some people laugh because they are nervous. Karen laughed because she believed consequences were for other people. I asked Ethan for his first document. He handed me a written estimate signed by Karen before the work began. The total was listed clearly. Materials, labor, emergency service fee, replacement components, tax, and final balance. Karen had initialed every page. I looked toward her. Did you sign this? Yes. Did you read it? She lifted one shoulder. I skimmed it. That answer told me more than she intended. People often imagine that admitting carelessness makes them less responsible. In court, it usually does the opposite. Then Ethan produced text messages. The first message from Karen read, "Please start immediately. I need this finished before Friday." The second read, "Whatever it costs, just get it done, read. You saved me. The tenants are moving in tomorrow." The courtroom went still. Karen's smile remained, but it was thinner now. I asked, "Did you send these messages?" "Yes, but he is taking them out of context." That phrase appears often when context has become dangerous. I asked her to provide the missing context. She looked toward the ceiling, sighed, and said, "The context is that I was being polite." Ethan finally raised his head, not dramatically, just enough I could see something in his face change. Not hope, not yet, but the first sign that someone in the room was finally listening. Then Karen made the mistake that began unraveling everything. I asked her why she waited until after the tenants moved in to complain. She laughed again, this time louder. "Judge, seriously, at your age, you still think people complain immediately. Real business doesn't work like that." The spectators froze. The bailiff looked toward me. Ethan's mouth tightened. Karen smirked, satisfied with herself. I did not respond immediately. Experience teaches restraint. If a person wants to reveal arrogance in front of a courtroom, sometimes the wisest response is patience. So I looked down at Ethan's file, and that is when I saw a small note clipped behind the final invoice. 3 words written in blue ink. "Tenant called again." I looked up. Karen was still smiling. She had no idea that the tenants she had mentioned so casually were about to become the most important people in the case, because one of them had recorded a phone call. And on that call, Karen said something that made her courtroom laughter disappear completely. The moment I saw the words "tenant called again," I stopped reading everything else. Not because the invoices no longer mattered, because years on the bench have taught me something most people never realize. The strongest witness in a courtroom is often the person nobody expected to become involved. The courtroom remained silent. Karen Whitmore still looked relaxed. She assumed the case was about invoices, about estimates, about repair costs. She had no idea it was about to become something much bigger. I looked toward Ethan. "You mentioned a tenant." "Yes, Your Honor." "Explain." Ethan took a slow breath. "I didn't want to involve them." Interesting. Not because he couldn't, because he didn't want to. That immediately caught my attention. People with weak cases usually drag everyone into court. People with strong cases often try not to. That distinction mattered a lot. Ethan explained that 3 days after completing the repairs, one of Karen's tenants contacted him directly. At first, he assumed they wanted maintenance advice. Instead, they asked him a very strange question. Interesting. Very interesting. The tenant asked, "Why is Karen telling everyone you never finished the repairs?" The courtroom became quiet. Karen looked toward Ethan for the first time since the hearing began, not smiling, just watching. Ethan continued. He explained that the tenant seemed genuinely confused because, according to the tenant, Karen had personally walked through the property after the repairs. She checked every room. She tested every appliance. She even thanked Ethan while standing in front of the tenants. Interesting. Very interesting. I looked toward Karen. "Did you inspect the completed work?" "Yes." "Were the systems operational?" "They appeared to be." Interesting answer. Very interesting. Notice the language. Not no, not they failed, just they appeared to be. Years on the bench teach you that people often soften their language when absolute statements become dangerous. Karen was beginning to soften hers. Then Ethan reached into another folder, smaller, much smaller. Inside was a handwritten note, not from him, from the tenant. Interesting, very interesting. I read it carefully. The tenant wrote that Karen gathered everyone in the kitchen after Ethan finished working. According to the note, she smiled and said, "Looks like we got lucky finding this guy." Interesting. Very interesting. I looked directly at Karen. "Did you make that statement?" A pause. "Then I don't remember." Interesting answer. Very interesting. Because people rarely forget complimenting someone who supposedly performed $31,000 worth of defective work. That observation stayed with me a lot. Then Ethan quietly said something he hadn't mentioned all morning. "Your Honor, I asked the tenant not to get involved." Interesting, very interesting. Why? Because they still live in Karen's property. The room became completely silent. Years on the bench teach you something important. People dependent upon someone else for housing rarely volunteer to testify against them, not unless they believe remaining silent would be worse. That mattered enormously. Then Ethan handed me an envelope. Simple white. No markings. Inside was a sworn affidavit. The tenant requested that their identity remain confidential during the early stages of the proceedings because they feared retaliation. Interesting. Very interesting. The affidavit described Karen celebrating the completed repairs, thanking Ethan Shosing the repaired systems to the tenants. Everything completely contradicted the lawsuits it now sitting in. Before me, Karen crossed her arms. Then she smiled again, not confidently, defensively. That difference mattered. Then she laughed, actually laughed. "This is ridiculous. The tenant doesn't know construction." Interesting. Very interesting. I looked at her calmly. They don't need to. They only need to know what they personally witnessed. The spectators nodded. Karen immediately interrupted. "They're lying." Interesting. Very interesting. "Do you have evidence they're lying?" Silence. Silence. Not a document, not a witness, nothing. Then Ethan quietly spoke again. "Your Honor, I didn't bring the recording because I thought it would upset them." The courtroom froze. Karen's expression changed instantly. Years on the bench teach you to watch people before evidence is introduced. Sometimes their face tells you exactly what's about to happen. Karen no longer smiled, not even a little. I looked toward Ethan. "You have a recording?" "Yes." "Who recorded it?" "The tenant." "Did Karen know she was being recorded?" "No." Interesting. Very interesting. Now I became interested. Not because hidden recordings automatically prove anything. They don't. But because honest conversations often happen when people believe no one else is listening. The courtroom remained perfectly still. I accepted the flash drive. Karen leaned forward for the first time all morning. That recording shouldn't matter. Interesting. Very interesting. She hadn't even heard my ruling on whether it would be admitted, yet she already wanted it excluded. Years on the bench teach you that people rarely fear recordings that help them. That observation mattered. A lot. I inserted the flash drive, pressed play for several seconds. Only ordinary conversation. Tenants unpacking boxes. Children laughing. Kitchen cabinets opening and closing. Nothing unusual. Then Karen's voice entered the recording, clear, calm, confident. And within the next 30 seconds, she said something so revealing that every person sitting inside my courtroom instinctively looked toward her, because in that single sentence, Karen accidentally admitted the real reason she never intended to pay Ethan in the first place. The moment Karen's voice came through the courtroom speakers, nobody moved, not Ethan, not the spectators, not even the bailiff. Years on the bench teach you that people instinctively recognize the sound of genuine evidence. The room became so quiet that the air conditioning was louder than anyone breathing. I let the recording play. At first, it sounded ordinary: kitchen cabinets closing, footsteps across hardwood floors, a child laughing somewhere in the background. One of the tenants thanked Karen for fixing the property before move-in day. Karen laughed softly. Then she said something that immediately caught my attention. "I told you I'd find somebody to get it done." Interesting, very interesting, nothing unusual. Not yet, I continued listening. Another tenant asked whether Ethan owned a large company. Karen answered without hesitation, "No, just a small business." Then came the sentence that changed the atmosphere inside my courtroom. Karen chuckled. Guys like him don't usually fight back. The room froze, docile silence. I didn't stop the recording. Years on the bench teach you that people often reveal more after believing they've already made their point. Another tenant laughed awkwardly. Then someone asked, "So, you're paying him today?" Karen answered immediately, "No, interesting, very interesting." A second tenant sounded confused. "But didn't he finish everything?" Karen replied. "That's not the point." The courtroom remained silent. I watched Ethan. He wasn't smiling. He wasn't celebrating. He simply lowered his head. That reaction stayed with me because he wasn't listening to accusations anymore. He was listening to confirmation that he hadn't imagined what happened. The recording continued. Another tenant asked, "What if he sues?" Karen laughed again, that same laugh, the one she brought into my courtroom. "I hope he does." Interesting, very interesting. The spectators exchanged stunned looks. Karen slowly looked down at the table. Then came the sentence that made me pause the recording. Not because it was loud, because it was calculated. Karen said, "He'll spend more chasing the money than the bill is worth." The courtroom remained perfectly still. I replayed that sentence once, then again, because every word mattered. Years on the bench teach you that intent is rarely announced so openly. Most people hide it. Karen advertised it. I looked directly at her. "Is that your voice?" A long silence followed, then, "Yes, interesting, very interesting." "Were you discussing Mr. Caldwell?" "Yes." "Did you say you hoped he would sue you?" Another pause. "Yes." The spectators looked from Karen to Ethan and back again. The emotional balance of the courtroom had completely shifted. Only 30 minutes earlier, Karen laughed every time Ethan spoke. Now nobody was laughing. Then Karen leaned forward. "I was joking." Interesting answer. Very interesting. Years on the bench teach you that jokes become remarkably popular the moment recordings become inconvenient. I asked a simple question. What exactly was funny? Silence. Karen opened her mouth, closed it, looked toward the ceiling, then back at me. She never answered. That silence mattered a lot. Then Ethan quietly reached for another folder. I noticed his hands were shaking slightly, not from fear, from relief. Months of frustration were finally beginning to make sense. He handed me a packet of emails. I didn't think I'd need these. Interesting, very interesting. Inside were emails exchanged after Karen refused payment. One message immediately stood out. Karen wrote, "My attorney says you don't have enough money to keep suing." Interesting, very interesting. I looked toward her. "Did an attorney tell you that?" "No. So why did you write it?" She hesitated. I assumed. Interesting, very interesting. Assumptions are dangerous, especially when they're used to pressure someone into abandoning a lawful claim. Then Ethan produced another exhibit, a calendar, not his, Karen's, printed directly from Discovery. According to the entries, only 3 days after refusing to pay Ethan, Karen scheduled an interior designer, interesting, very interesting, then a granite installer, then custom lighting consultants. The renovation hadn't stopped. It had continued with other contractors. I looked toward Karen. If Mr. Caldwell abandoned the project, why were new contractors entering a fully functional property only days later? Karen swallowed. They were making improvements. Interesting, Very interesting. So Mr. Caldwell restored the property. Then you upgraded it, and yet you told this court the property was left unusable. No answer. None. The spectators leaned forward again because everyone could feel it. Karen's story wasn't simply weakening anymore. It was collapsing. Then I noticed one final email tucked behind the calendar entries. It wasn't sent to Ethan. It wasn't sent to a lawyer. It was sent to Karen's property manager. The subject line alone made me stop reading. Interesting, very interesting. I opened it, read the first paragraph, then immediately looked back toward Karen, because buried inside that email was a single instruction, one sentence, one deliberate instruction. That proved this lawsuit wasn't the result of confusion. It had been planned weeks before anyone ever stepped into my courtroom. The moment I opened Karen Whitmore's email to her property manager, I stopped speaking. Years on the bench teach you that silence has a purpose. If a document has the power to change an entire case, you don't rush it. You let everyone in the courtroom understand exactly what they're about to hear. The courtroom remained perfectly still. Karen no longer leaned back in her chair. The confidence she wore that morning had quietly disappeared. Ethan watched me carefully. He wasn't trying to guess my decision. He was trying to understand whether someone finally believed him. I began reading. The email had been sent only 6 hours after Ethan completed the repairs. Interesting, very interesting. The subject line read, "Don't mention the repairs." I continued. Karen wrote, "If Ethan comes by asking about payment, don't tell him the tenants are already moved in." The spectators exchanged confused looks. I kept reading. "Tell him we're still waiting on inspections." Interesting. Very interesting. I paused, looked toward Karen. "Were the inspections already complete when you wrote this?" She hesitated. "Yes." Interesting. Very interesting. "So you instructed your property manager to tell Mr. Caldwell something you already knew was false." Silence. Silence. Years on the bench teach you that some lies are complicated. Others are surprisingly simple. This one was simple. Then I continued reading. "If he thinks the project isn't finished, maybe he'll stop asking for payment until I figure this out." The courtroom froze. No one moved, not even Karen. I slowly lowered the paper. The room had changed. An hour earlier this had sounded like a payment dispute. Now, it was beginning to sound like a deliberate strategy. I looked directly at Karen. "What exactly were you trying to figure out?" She answered quietly. "My finances." Interesting. Very interesting. That answer was honest. Perhaps the first completely honest answer she had given all morning. Years on the bench teach you something important. People in financial trouble deserve fairness. They deserve patience. They deserve lawful payment arrangements. What they do not deserve is permission to deceive someone else because paying has become inconvenient. That distinction matters. A lot. Karen nodded slowly. I didn't have the money. The courtroom remained silent. Ethan looked at her for the first time since the hearing began. There wasn't anger in his face. There was disappointment, real disappointment. He quietly said, "If you had just told me." Then he stopped. He never finished the sentence. Sometimes unfinished sentences carry more weight than finished ones. Then Ethan reached into his briefcase. "I have one more thing, Your Honor." Interesting, very interesting. Unlike earlier exhibits, this wasn't a folder. It was a small notebook, worn coffee stains on the cover. Nothing impressive. I opened it. It was Ethan's daily work journal. Every contractor I know keeps notes differently. Some use apps, some use calendars, some write everything down. Ethan wrote everything. Arrival times, material deliveries, weather upon calls, conversations, everything. Interesting, very interesting. One page immediately caught my attention. October 9. The day Karen claimed she first discovered the so-called defective work Ethan had written, Karen requested 30-day extension, said cash flow problem, promised full payment after new tenant's deposits clear. Asterisk, I looked toward Karen. Did that conversation happen? She closed her eyes. Yes. Interesting. Very interesting. So over a month before filing this lawsuit, you admitted the issue was cash flow. Another pause. Yes. The courtroom remained silent. Years on the bench teach you that truthful stories usually become stronger over time. False stories require constant repairs. Karen had spent months repairing hers, and every repair created another crack. Then something unexpected happened. Karen suddenly interrupted, not loudly, not angrily, almost desperately. He's making me sound like a criminal. Interesting, very interesting, I answered calmly. No, Miss Whitmore, the documents are doing that. The room became so quiet that several spectators slowly lowered their heads because everyone understood the difference. I wasn't accusing her. Her own emails, her own messages, her own promises, her own recordings were speaking for themselves. Then the bailiff quietly approached my bench. He handed me a single envelope that had just been delivered by the court clerk. Interesting. Very interesting. It wasn't from Ethan. It wasn't from Karen. It came from someone neither side had planned to call, a certified forensic accountant. Attached was a financial analysis Karen had been ordered to produce during discovery. I opened the report, read the first page, then the second. And honestly, I immediately understood why Karen never wanted this report discussed in open court, because according to her own bank records, she had enough money to pay Ethan the entire time. She simply chose to spend it somewhere else. The moment I reached the second page of the forensic accountant's report, I stopped turning pages, not because there wasn't more to read, because I had already found the question I needed answered. Years on the bench teach you that money leaves footprints. People can rewrite emails. They can rehearse testimony. They can even convince themselves their version of events is true. But financial records are remarkably stubborn. They tell their story whether people like it or not. The courtroom remained silent. Karen Whitmore watched me without blinking. Ethan Caldwell sat perfectly still. The spectators leaned forward. Nobody wanted to miss what came next. I reviewed the transaction history. Interesting. Very interesting. Karen had repeatedly testified that she delayed paying Ethan because she simply didn't have the money. That was the foundation of her explanation, not her lawsuit, her explanation. There is an important difference. The lawsuit claimed defective work. Her testimony claimed financial hardship. Now I had objective records, bank deposits, outgoing transfers, credit card statements. Everything arranged chronologically. Interesting, very interesting. The first payment immediately caught my attention. 5 days after Ethan completed the repairs, Karen purchased a luxury SUV. The down payment alone exceeded $18,000. The courtroom became noticeably quieter. I looked toward Karen. "Did you purchase this vehicle?" She answered softly. "Yes." Interesting. Very interesting. "Was this after Mr. Caldwell completed the repairs?" "Yes." I nodded, then continued reading. 2 days later, a luxury furniture store, almost $9,000. The following week, a high-end vacation package, another substantial payment. Interesting, very interesting. Then came something I did not expect. The accountant's summary highlighted that throughout the entire period Karen claimed she could not pay Ethan, her average checking account balance never dropped below $74,000. The room froze, almost silence. Several spectators looked at one another. One man quietly shook his head. I looked directly at Karen. "You testified you didn't have the money." She swallowed. "I meant..." Then she stopped. Years on the bench teach you that people often discover halfway through an answer that finishing it would only make things worse. I waited. Finally, she spoke again. I meant I didn't want to spend that money. Interesting. Very interesting. That single sentence changed everything. Not because people cannot choose how to spend their money. They can. But because moments earlier she had blamed financial hardship. Now she admitted it had been a financial choice, not a financial necessity. That distinction mattered enormously. Then Ethan quietly placed both hands on the table. He wasn't smiling. He wasn't celebrating. He looked exhausted. Honestly, that affected me more than anything Karen had said all morning. Years on the bench teach you that small business owners rarely sue because they enjoy litigation. Most sue because they run out of alternatives. I asked Ethan one question. What happened when this invoice went unpaid? He took a slow breath. I couldn't pay 2 of my technicians on time. The courtroom became silent. I had to borrow money from my father. Another pause. My daughter missed a school trip because I couldn't justify spending the money. He immediately lowered his eyes. I promised her we'd make it up next year. Nobody spoke, not even Karen. That is something people often forget about civil lawsuits. Numbers on paper usually belong to real lives. $31,000 wasn't simply an invoice. It represented payroll, family plans, business obligations, people. Then I looked back toward Karen. Did you know Mr. Caldwell operated a small business? Yes. Did you know delayed payment could affect his employees? Yes. Interesting, very interesting. Then I returned to the forensic report. One final section remained. The accountant compared Karen's testimony with her discovery responses. A highlighted paragraph immediately caught my attention. According to the report, Karen transferred $32,000 into a newly opened investment account only 48 hours before claiming in court that she lacked the funds to pay Ethan. Interesting. Very interesting. The timing was extraordinary. I looked directly at Karen. Why transfer almost the exact amount you owed 2 days before refusing payment? She looked down. A very long silence followed. Then, for the first time all day, she answered without arguing. I didn't want him to get it. The courtroom froze. Damseled silence. No whispers. No movement. Nothing. Even Ethan closed his eyes. Because after months of emails, invoices, excuses, recordings, and contradictory testimony, the truth had finally arrived, not through cross-examination, not through a witness, but through Karen's own words. I didn't want him to get it. I slowly placed the report back on the bench. Years on the bench teach you that there comes a moment in certain cases when the evidence no longer needs help. It simply stands on its own. Karen's laughter from earlier that morning felt like it had happened days ago. The woman who mocked every question now struggled to answer even the simplest one. And honestly, the verdict itself was no longer the most significant consequence she faced, because while reviewing the accountant's report, I noticed a certification attached to the final page. A certification stating that several of Karen's sworn financial disclosures to the court did not match the bank records obtained by subpoena. That meant this hearing was no longer just about an unpaid invoice. It had become a question of whether Karen had lied under oath, and that was something I intended to address before anyone walked out of my courtroom. I have presided over enough cases to know that money changes people. Sometimes it reveals generosity, sometimes it reveals fear, and sometimes it reveals character that has been carefully hidden for years. The courtroom remained silent. Karen Whitmore sat motionless. The woman who had laughed at my questions only hours earlier now avoided everyone's eyes. Ethan Caldwell remained exactly where he had been since the hearing began, quiet, respectful, Papadon. That contrast stayed with me. Years on the bench teach you that the strongest impression is rarely made by the loudest person in the room. It is usually made by the one who remains consistent from beginning to end. I looked down at the forensic accountant's report one final time. Every transaction had been verified. Every bank statement authenticated. Every transfer matched records obtained directly from the financial institution. There was no confusion, no missing context, no misunderstanding. The numbers spoke with remarkable clarity. I looked directly at Karen, Miss Whitmore. She slowly lifted her head. A few hours ago you laughed while Mr. Caldwell explained what this unpaid invoice had done to his business. She didn't answer. You laughed when I asked simple questions. Still nothing. You laughed because you believed this courtroom would never reach the truth. The room remained perfectly still. Then I asked the question that mattered most. When you signed your financial disclosure under penalty of perjury, did you know these bank transfers existed? A long silence followed, the longest silence of the entire hearing. Years on the bench teach you never to interrupt silence. People often tell the truth simply because they can no longer carry it. Karen finally nodded. Yes. Interesting. Very interesting. You understood the court expected complete and truthful financial disclosures. Yes, and despite knowing that, you chose not to disclose these accounts. Another pause. Then, almost inaudibly, yes. The courtroom froze. Nobody moved. Nobody whispered. Even the spectators seemed to understand that something important had just happened. Because this case was never only about $31,000. It had become about honesty, about responsibility, about whether someone believed the rules applied equally to everyone. I leaned back for a moment, not because I needed time to decide. The decision had already been made. I wanted everyone in that courtroom to understand why. Years on the bench teach you that contracts are built on trust. Businesses survive because people honor agreements. When someone accepts the benefit of another person's work, moves tenants into a repaired property, collects rental income, thanks the contractor, and then deliberately creates excuses to avoid payment, that is not clever business. It is a betrayal of trust. I turned toward Ethan, Mr. Caldwell. He looked up. You attempted to resolve this dispute privately. Yes, Your Honor. You offered payment extensions. Yes. You continued answering maintenance questions even after payment was withheld. Yes. You never disabled the repairs. No, Your Honor. Interesting. Very interesting. That answer mattered. He could have walked away. Instead, he continued helping the very person refusing to pay him because he didn't want innocent tenants to suffer. Character often reveals itself most clearly when no one is watching. Then I looked back at Karen. Ms. Whitmore, there is a difference between negotiating. There is a difference between experiencing financial hardship, PIAP, and there is a difference between intentionally refusing to pay someone after receiving exactly what you requested. You crossed that line. The courtroom remained silent. Then I said the sentence that finally erased every trace of the confidence she brought into my courtroom. You didn't outsmart Mr. Caldwell. You simply underestimated the truth. Karen closed her eyes. A single tear rolled down her face. Not dramatic, not theatrical, just quiet. For the first time all day, she understood that arrogance had accomplished nothing except making the evidence even more powerful. I entered judgment in favor of Ethan Caldwell. The full unpaid contract balance was awarded, along with allowable court costs, statutory interest, and the additional relief authorized under the governing law. The documentary evidence overwhelmingly supported his claim. Karen's allegations of defective work were unsupported. Her own text messages contradicted her testimony. Her own emails contradicted her testimony. Her own recorded statements contradicted her testimony. And finally, her own financial records contradicted her testimony. Every road led to the same destination, the truth. Then I addressed Karen one last time. I cannot tell you how to run your business. I cannot tell you how to spend your money. But I can tell you this. The moment you believe another person's hard work has less value simply because their business is smaller than yours, you've already begun making very expensive mistakes. She didn't respond. There was nothing left to say. As Ethan gathered his folders, he paused beside the counsel table. He looked toward Karen. For a brief moment, I thought he might say something. He didn't. He simply wished her well and quietly walked out of the courtroom. Honestly, that affected me more than the verdict itself, because dignity has a way of exposing arrogance without ever raising its voice. Years later, I still remember Karen's laughter, not because it offended me. Judges hear disrespect more often than people imagine. I remember it because of how quickly confidence disappeared once facts replaced assumptions. People often believe intelligence is measured by who speaks the loudest. It isn't. Some believe winning means humiliating the other side. It doesn't. Real strength is honoring your word, even when keeping it becomes difficult. Real integrity is admitting the truth before someone else proves it for you. Karen entered my courtroom convinced that laughter would make her appear stronger than the man sitting across from her. She left understanding something she should have known from the beginning. A courtroom is the one place where arrogance has no legal value. Evidence does. Honesty does. Character does. And in every courtroom I have ever served, the truth never needs to laugh. It only needs enough time to be heard.